If it please the court, my name is Tom Gard. I'm from the firm of Adams and Reese. I'm here on behalf of the appellant Gil Bain Building Company. I would respectfully ask if I reserve 5 minutes for rebuttal. We're here on an appeal of an order denying Gil Bain's motion for attorney's fees based upon 2 proposals for settlement that were served during the progress of the case. This order followed a 6-day trial upon a complaint filed by Sarasota County versus Gil Bain on November 30th, 2016, resulting in a final judgment in favor of Gil Bain on August 31st, 2021. That final judgment was affirmed on appeal of August 12th of this year. The order denying the motion for fees was based upon a finding of the trial court that the proposals did not fit the particularity requirements of Florida Rules of Procedure 1.442. The proposals provided in a release attached to the proposals that the parties hereto have agreed to keep the terms of this release and any settlement discussions related to this release confidential, and the terms shall not be disclosed to any other person or entity except the parties' respective accountants, counsel, who are bound by the confidentiality provisions. In its findings, of which there were very few, if any, factual findings by the court, the trial court relied upon the opinion of this court in the Disadieu versus Lewis, found at 223 Southern 3rd, 1015, which the county neither cited in its original proposals to the trial court, nor in its response to the motion for fees, and only tangentially referenced it in its answer brief to the initial brief. Rather, the county has founded its complaint about the sufficiencies of the proposals upon Florida Statute 69.081. That statute deals with claims against the county, not those found by the county, as we have set forth in both the initial and the reply brief.
It also deals with public hazards.
I'm sorry?
It also deals with public hazards.
That is correct, Your Honor.
And are we dealing with any public hazards?
We are not dealing with a public hazard here, Your Honor.
All that, notwithstanding the reliance on that particular statute, is there actually a question as to whether this would have to be disclosed under Chapter 119 if a request was made for it?
Your Honor, there is no indication, nor was there any cases cited that would indicate that it had to be disclosed. There is a fleeting reference to 2 statutes, Chapter 119, that talks generally about public records without this particular issue. The other is 286.011 dealing with public records and meetings. In that case, that allowed for the county to hold a shade meeting if they, in fact, and we'll get back to that, but if they are in fact were concerned about the confidentiality provision in there.
Which they obviously weren't.
Which they obviously were not. They could have held a shade meeting at which they could have dealt with the issue. After that shade meeting and after the case was over, then there could have been an issue about the publication of the release. That was not the case here. Instead, the county took it upon themselves to publish this proposal in an open meeting to Sarasota County, in which the proposal, the release, argument of the attorneys in favor of the county were all vetted in front of a public forum. At that point, there was never an issue raised about the confidentiality that was contained in the release. That issue was not raised until the motion for attorneys.
But you don't have to raise any sort of, there's no obligation on the offeree to raise an objection during the 30-day time period to reject it, correct?
That is correct, Your Honor. There is none. But that case that was cited by the trial court is not applicable here because we don't have a situation where we had simply said you should have raised it. And I'll go back to this court's opinion in Disadieu here in a minute, where you have put the litigants on notice that the better thing to do is to raise that issue during the trial itself and not wait until the end to raise it. But in our case, we're talking about 2 issues. First of all, there's a question as to whether or not it had to be disclosed at all, the release, because there is no evidence of any settlement discussions. Second of all, the particular clause was totally severable from the balance of the proposal. And the county has cited no case to show otherwise in either its answer brief.
But does the case law allow in offers of settlement and proposals allow severance of provisions?
Well, it doesn't prohibit it.
Well, I understand that, but it's very specific as to, it has to be, you know, there's particularity and it has to be, you know, this is what is offered, this is what you're accepting. And unfortunately, there was this confidentiality in the release, which is probably some boilerplate language left in.
That is correct, Your Honor. It is boilerplate language that's left in there, but all the cases that deal with proposals of settlement are founded usually on two grounds. Either they're disallowed because of bad faith, or they're disallowed because of ambiguity. In other words, if you look at the cases cited by both parties, there was some ambiguity within the proposal itself that prohibited the county, or in this case, the offeree, from accepting a proposal.
But in making a proposal for settlement, there's this, you know, concept about a mirror image. You got to be accepting what's on the table. I'm troubled by the notion that post hoc, the court's going to get involved and tell a party what it is they agreed to or didn't agree to in accepting or rejecting a proposal.
Well, Judge, I think there is some application of that. The cases cited by the county all deal with proposals of settlement. There were written offers of settlement not under 1442, 1.442. There are no cases there, excuse me, cited by the county that would apply here. But the third reason is waiver, and waiver is found throughout the statutes, including in the provisions that were contained in the mediation.
Waiver because they didn't object during the time period?
It was a waiver because they went ahead and published it at the time that they published it out there to the entire world. They waived that issue. And in fact, the issue was waived by Gilbane when they served the proposal on the county. If in fact this proposal falls within 119 and it is a public record, it became a public record as soon as it came into the county's hands, which means that
But the whole point, I mean, the whole point of serving offers and proposals is to end litigation. And I don't know if I necessarily like the idea that a blue pencil can come in after the fact and start severing. Because
Well,
that defeats the whole point.
yes, Your Honor, but it would have been the issue that would have been raised by Gilbane, not the county. When they published it to the entire world, at that point, Gilbane, had they wished to, would have cried foul at that point, and that you have violated the terms of the release.
If it had been signed and accepted by the county.
Or at the time that they offered it to the county. As soon as they offered it up, that's when, if anything happened, there was a derogation of the terms of the release. That was never done.
I guess the question would be, was there a waiver when, if you knew you were sending it to the county, you knew they were going to have a hearing on it, that it was public, then I guess it would have been waived by your client first.
That's correct, Your Honor. It was waived at the time that we filed, or that we served it on them. And if it wasn't waived then, it was certainly waived at the time that we filed it in the court file in order to move forward with our motion for attorney's fees. So there is a complete waiver on both sides. Even if the issue had, that the release had to be disclosed under 119, which was not argued, nor was there a factual basis established in the trial court. The trial court established, the trial court based its entire position on the December case. And in that case was distinctly different from what we have in front of this court. In that case, there was a loss of consortium claim that the particular offeree didn't have. And since the release required it to be waived, they had the inability to do it. They cited to the State Farm case, another one where there was a waiver implied in the release of all claims and PIP claims that were not part of that litigation. It's those kinds of cases that the courts have traditionally found to be ambiguous or lack of particularity necessary under 1.442. That's just not the case here. And I cite back to the court.
And then let me just stop. And in those cases, your position is it's impossible when Decidu talks about the proposal being impossible for the offeree to meet its terms, that's because in your position, meeting its terms is also contingent on the acts of a third party.
Yes,
So
it's,
the offeree themselves cannot fulfill the obligations.
That's correct.
Because they don't have the power.
that is correct. And I hearken back to the various language that I think in various cases, including the State Farm versus Nichols case that was referenced by the trial court, where the proposal for settlement statute, the proposal for settlement rule was not supposed to revamp contract law. It condemned the nitpicking that comes about when you're trying to take one specific issue that had nothing to do with whether or not the county did or couldn't accept a proposal, but rather comes in ad hoc, as this court mentioned in the Decidu case, and then comes in later and says, oh, by the way, we got you. The whole purpose of the 1.442 and the offer of judgment statute is to limit litigation, not to promote it. So it ought to have some construction that we don't have a situation where you've got this one particular issue in here that has nothing to do with the claim. It's got nothing to do with what was being offered and what claims you're giving up and how much money I'm paying and to whom, but rather an ad hoc determination that for some reason, now I've got you because there is this one clause in here that, by the way, we never felt was important to start with. We never considered it. And it wasn't even vetted until after the proposals were served, the motion was filed, and the proposals were filed. And I don't know where I am on time, but I will reserve some for back end.
You'll have your 5 minutes for rebuttal. Thank you.
Thank you, Judge.
Good morning.
Good morning, may it please the court. Assistant County Attorney Scott Foster here on behalf of Sarasota County. I don't anticipate having 20 minutes worth of remarks, but if I get 2 minutes left, please let me know.
Will do.
Appreciate it. Begin by saying first that the trial court was correct in this case to deny the attorney's fees in this case because, as Judge pointed out, it was impossible for the county to accept the offer as proposed. It included language in there that had us to keep the settlement confidential. We're simply not allowed to do that.
It seems though that this argument is one of convenience after the fact.
That it would seem that way, but at the same
So help
time,
me show that it's not.
well, I think looking at this case overall, there's a couple of important points that are kind of overarching the whole thing. And one's about proposal for settlement as a total, and then the public records aspect of it. With proposals of settlement, they're punitive in nature, derogation of the common law. They're supposed to be strictly construed. And one of the reasons they're strictly construed is because it's an offer for a unilateral contract. So it's the wanted poster to bring in the outlaw. And if that wanted poster says, bring in the outlaw with a blue shirt on, and someone captures the outlaw, he's wearing a green shirt, that's not an acceptance of that unilateral contract. It's that precise, has to be that precise, because the outcome is fees. And as Decidu in other cases have noted, it's, if all the terms cannot be met, it cannot be enforced.
But okay, but it focuses on, those cases focus on impossibility. So here, as far as confidentiality, there were measures though that the county could have done to keep it confidential, but they chose not to, like in the form, for example, with the shade meeting.
True.
And so, it's hard, I'm struggling with the fact that one side hands it over, there's a meeting, obviously it's going to be public, it's a public meeting. And the county doesn't necessarily care about the provision either. And we have the memo from the county attorney recommending the denial. And there's nothing in there that talks about the importance of the confidentiality. And so when I'm thinking of impossibility, those cases, they're considering whether or not it's, usually there's like a third party, but here the actions are with the county itself, so.
Right. And it very well may be, and I'm, not privy to the conversations that were had or discussions that were had, but.
And they're not in the record.
And on the record, but certainly it's not outside of the realm of possibility that, if you have a proposal or settlement that's got a number in it, and that's the main focus usually of these things is the number. And if there's a dissatisfaction with that number, and that's the reason to reject it, you don't necessarily go through the rest of the proposal to hash out any other issues that there might be. You reach a decision based on whatever other issues there are with that proposal and you reject it.
And then you fast forward to today, and you have a confidentiality clause, and then you put your argument on that.
Right, and so, again, it's incumbent upon the proposer to make sure that the proposal satisfies the particular requirement. And it's lost my train of thought for a second. Excuse me. I think this goes back to the language in Dyson, the case this court had. It talked about it being a better practice to say, hey, you messed up the proposal. We can agree to this, but we can do it if we do this instead of that. Now, what that is it's a counteroffer at that point. The offer is rejected anyway at that point. Because you said, we don't mind the, let's say, for example, hypothetically, we say, we don't mind the number that you proposed to us, but as we've tracked down through this agreement, we found a clause, we don't like your release. We want to use our release. Well, that's a counteroffer. Counteroffer means the offer is rejected. So it's a voluntary kind of act, this proposal for settlement that's kind of self-initiated. That doesn't prevent the parties from bilateral negotiations, doesn't prevent a settlement from being reached in other ways.
I guess the root of it is if Gilbane didn't really consider this to be confidential because it went to the county and it was published for the meeting and everything, and then the county didn't treat it as confidential either. I'm curious, what are we supposed to, I don't know that this fits in any case that I've seen. And I'm curious what we're supposed to do with that, and how we're supposed to handle that, or just ignore it as.
Yeah, I understand. And it doesn't fit squarely in any appellate level cases that we found. We did cite a couple of circuit level cases that kind of touched on the applicability of confidentiality in that context.
And the Public Records Act, yes.
Yeah, public records. And then even the other case, the Ray case, which is out of Duval County, it simply only included the word confidentiality in the proposal. Didn't even have a release or any kind of agreement to it. Just simply had the word popped in there somewhere. And that was enough to say, this is not acceptable, not enforceable. It's
But in that case,
ambiguous
the release,
because
but
it's
in,
even
yeah, but
included
I
that
think in
word.
that, I think in that case, the release wasn't even attached, and that's clearly not what we have here. We actually have the terms of what the release are.
Correct. And again, the release is another voluntary step that a proposer takes. Release is not a required element. The proposal can be without one. But once you put that release in, it's got to meet that particularity requirement. It's got to be something that we can accept in whole. And to your point, even if none of the parties really were concerned about the confidentiality of the proposal itself, we are not allowed to agree to keep something confidential. And if we can't agree to it, we can't possibly accept it. But what we have also, and I know council mentioned whether we had cases on certain issues, but what they don't have is a case on point that says we could have accepted this proposal as stated. That we could have, had a kind of handshake agreement that we won't honor that
Can you-
clause.
But can you
But we'll agree to it
concede,
anyway.
can you concede we're not dealing with public hazard? And we're not dealing with chapter
Yes.
69?
Yes. The point there was to indicate that, claim or action didn't just mean action, it meant claim, any claim. But again, the overarching point is 11907. There's no exception for us to accept something to keep an agreement confidential. I don't think there's any desire for the state to have the expense of public funds be made confidential just by agreement. And that's what it would be saying if we simply agreed to it. If there's some side understanding that we're not going to enforce this, that in itself is another, presumably counteroffer with another offer. Because we're not accepting the agreement as stated, we're saying we're accepting the agreement, but we're making an amendment to it somehow. And now we're out of that loop again. We're making more of a bilateral agreement at that point. Not an acceptance.
Although it looks like
of the
both parties
proposal.
actually struck it by their actions.
Say it.
It looks like both parties actually struck it by their actions.
Certainly by their actions, but at the end of the day, if we're gonna accept that settlement and we're gonna accept that release, we're accepting that language. We're just not permitted to accept that language without an exception to the public records law. Unless there's any more questions, I think I've made the points in the brief as the arguments were laid out there in the case law as well. We would ask that the court affirm the order below as correct and denying the guilt made the attorney's fee. Thank you for your time this morning.
Thank you very much. Mr. Dart?
Please, court. Just briefly. We have cited in the brief a number of cases in contract law where portions of an agreement can be severed. And if it does not go to the materiality of the agreement, it doesn't go to price, it doesn't go to terms, it doesn't go to liability.
But those aren't those cases where an agreement actually was entered? Right?
That is correct, Your Honor.
Okay, and we don't have that here.
I agree, but in terms of what could be severed, and what I'm trying to promote to the court here is that there's no factual basis developed for the county, nor was there anything within the trial court's findings that got to the issue as to whether or not it was going to be enforceable and whether it could be severed. In fact, there was no facts developed at all, as the court has noticed that it was in fact not being able to be disclosed.
But Mr. Dart, arguing for severance just opens up another avenue of a lot of litigation over a statute that was meant to get rid of litigation.
Well,
The fact is, nobody can seem to get any of these things right.
well, Judge, that is correct. The reason why I'm trying to address that is because Judge Smith asked the question, and in fact, the statute that was relied upon by the county, in fact, in 69081, which is where they hung their hat, the statute it says any portion of an agreement is void. So it never had any effect to start with. And if it was void from the inception, then it didn't go to the materiality of the offer. In getting back to, I think, the stronger points of the argument, frankly, is that it was waived by the parties. It was never a material portion of what was being done here. It didn't affect the amount being paid. It didn't affect what claims were being released, as all the other cases that have talked about specificity and ambiguity have gone to.
Are there really cases that talk about that concept, materiality of terms?
There are, we've cited some in the brief, Your Honor, in terms of what would cause an issue to be a problem if it doesn't go to the essence of the contract, it doesn't go to the consideration being paid, it doesn't go to the terms that are being released.
So I'm concerned, Supreme Court will toss these things out on the slightest defect.
Judge, I recognize that the courts have not been friendly to the offer of judgment statute. I personally don't understand why, because we're trying to limit litigation. I also understand that we've taken the issue off the table now with the Supreme Court's modification to 1.442, that any non-monetary terms are out. Frankly, I wish they'd done that a long time ago. But it doesn't change the fact that in these facts of this case, none of these facts fit within the cases that are cited by the trial court, nor by the county. All of those don't deal with the issue before us. And to say that there is never any waiver, or there could be a waiver of a term, I think goes against a couple of 100 years of contract law. And if we're going to get into this issue about it being a contract of some sort, about a mere acceptance, et cetera, waiver is a definite portion of this. And it's in fact part of the mediation statute that the parties can waive confidentiality. So if we even looked at the other statutory constructions about
But those,
confidentiality.
but those don't apply. I guess, you know, the concern here is that everybody knows that if you're doing an offer or doing a proposal, I mean, you go and you do it by the letter. And the problem here is that the drafting of this offer included, you know, for whatever reason, included this confidentiality, which, you know, public records is going to exclude that. So anyway, I just, in drafting it, people know you've got to, you know, you've got to be really careful, because a lot of these things, as Judge Rose said, on technicalities get thrown out. And here, you know, county may benefit from that technicality.
They could, I'm not sure equitably they should. But if this court so finds that that makes the entire offer void or makes it unenforceable, when it is a tangential issue to the actual offer itself, which is we'll pay you this, we'll pay you this, and you release the claims. And oh, by the way, sign this release. And as the Kerry versus Allstate, the Kerry Allstate versus Newby case said, unless the ambiguity goes to the essence of the agreement and affects the decision, it should be allowed.